Hi, my name is Cindy. It's January 22nd, 2026. Happy New Year. I'm happy to welcome you. I'm here at Russo Law Group. We're here to attend this webinar with Diana Latanzio, Beyond Resolutions, Protect Your Assets in the New Year. Before we get started, let's start with some housekeeping items. This webinar will run 30 minutes. It will be recorded and a copy of the recording will be emailed to you. Your microphones have been muted for the remainder of the presentation. Please feel free to submit your questions in the Q&A box. Diana will address them at the end of the webinar and chat amongst yourselves in the chat box. As always, we value your feedback, so please submit the survey that will be presented to you at the end of the webinar. I'd like to introduce our presenter, Diana Latanzio. She's a partner here at Russo Law Group. She has over 20 years experience in the practice areas of special needs planning, Medicaid planning, and trust and estate planning. She's licensed to practice in New York State and New Jersey. And with that, Diana, I'll pass it over to you.
Okay, thank you, Cindy. Welcome, everyone. Good afternoon. Thank you for joining me today. We are 22 days into the new year. I hope you are all maintaining your New Year's resolutions, and I hope I could add an additional one for you for everyone to either check their estate plans or to think about creating one. And I will educate you on that today. So today we will cover a lot in a short period of time. We're going to discuss decision-making documents, leaving assets to your family in a secure way, and protecting your assets in the event that you need long-term care. So I'm going to start with the decision-making documents. The analogy I like to give when I present on this topic is that similar to building a house, creating a comprehensive estate plan always starts with a foundation. And so the foundation is comprised of a set of documents that are referred to as advance directives. Whether you have very little or you have a lot, the foundation is always the same and starts with these set of documents. And on the screen, there are three that are very important out of this set: a durable power of attorney, healthcare proxy, and a living will, which I'll get into in a moment. So a durable power of attorney, in my opinion, is a crucial document for everyone to have. It's probably the most important document in an estate plan. It is a document that allows you, while you are of sound mind and body, to appoint an agent that would step into your shoes and handle any legal or financial matters for you in the event that you are incapacitated at a future date. And that incapacity can be a physical incapacity. So I have a lot of clients that have strokes, and unfortunately, sometimes that leaves them paralyzed and unable to sign their name. Or, you fall, you hit your head, you have a brain injury, or some type of short-term memory loss, dementia, or Alzheimer's. So it's used to basically allow someone that you trust to make any and all legal and financial decisions for you. And like I said, it's really crucial in planning, especially with married couples that own real estate jointly. Next slide, please. The second document is a healthcare proxy. So that is similar to a power of attorney, but it is for medical decisions. And it doesn't have to be the same agent that you're appointing on your, a durable power of attorney for financial decisions, for your healthcare decisions. You can bifurcate it. And so this would be a person, again, that person can't trump what you want regarding your medical treatment. But if you can't speak, if you're speaking and you're not making any sense, if you're in a coma and unable to speak, this person would guide and control your medical treatment. So it's very important that that person is well aware of what you would want in that event, and that your decisions are made in accordance with, your beliefs and maybe your faith as well. Living wills are part of the medical directives, And this is a document that would allow you to memorialize your wishes regarding end of life decisions. So basically, we can get into very specifics and you can tailor it exactly to what your wishes are. If you want a blood transfusion, if you would want surgery, chemotherapy, a respirator, pacemaker, dialysis. So it really gets into the nitty gritty of end of life decisions. And again, it allows you to take control and assures that the person that you're appointing to make these very important decisions isn't guessing at all. You've basically have guided them, memorialized your wishes into a document that they can read and be well versed as to what you would want, God forbid, that should ever occur. A HIPAA authorization is a release of medical information, and it is also part of the medical directives. And it's a disclosure of medical information. So all of our medical records are sealed and private to protect our privacy. But in this event, if someone's making a major medical decision for you, he or she would need disclosure. We want them to make sure they're getting apprised as to what the prognosis is, diagnostic test results, so that they can make an informed decision. So what happens if you don't have a plan? Basically, it's very disheartening when I meet with clients who don't have these documents and that ship has sailed, unfortunately, and they do not have the capacity or the ability to sign the documents at the time of crisis. And so what usually happens, there is a remedy. It's a court proceeding called a guardianship proceeding. And it's basically asking a judge to have you deemed incapacitated and appoint a legal guardian on your behalf. So there is a path to have that result, but it is costly, a bit invasive, because basically the courts would be in your life for the remainder of your life and have to consent to certain major decisions that the guardian is making as well. So it's not the least restrictive means to that result. How to leave assets to your family in a secure way. So what most people don't know is that if you pass away a resident of New York and you don't have any estate planning documents in place by virtue of a last will and testament or a trust, New York State has a law called the law of intestacy, where New York decides for you how your assets get distributed. And it may not be what you want. So we're going to discuss a last will and testament and how that document is a great tool in allowing you to control the disposition of your hard-earned assets. So instead of relying on a statute that decides for you, you can trump that decision and pick beneficiaries of your choice. So I met with a client yesterday, actually, and she has, siblings, unmarried, no children, but does have siblings, nieces, nephews. But she's not very close to them, and that's not who she wants to inherit her assets. And so a last will and testament would be, a great option for her to be able to control where her money and her properties ultimately land. Trusts are great estate planning tools. So trusts are needed if you want to avoid a court proceeding. So if you have nothing in place at all and you are relying on New York State law of intestacy, when you pass away, there would be a court proceeding called an administration proceeding to get the assets to the heirs. With a will, there is a similar proceeding. It's called a probate proceeding. And that's basically notifying your next of kin that this proceeding is being commenced, giving them an opportunity to contest the will, and then ultimately having the judge grants authority to your executor to collect all of the assets and distribute it in accordance with your wishes. So having a trust would avoid that court proceeding. There are different types of trusts. There are two types. There are revocable and irrevocable trusts. So a revocable trust makes sense when your primary goal is to avoid a court proceeding. So I usually use this tool if I have a client that wants to be still 100% in control of everything during their lifetime in terms of being able to sell property and still use their assets the way that they've been used to. But they own properties in different states, so real estate in different states. So oftentimes it's primary residence in New York and, secondary investment property or a secondary home in Florida or the Carolinas. And so when that person passes away, there would be a primary proceeding, probate proceeding that would be necessary in New York, and what's called an ancillary proceeding in that other state. Because we wouldn't have jurisdiction over the real estate in that secondary state. So a revocable trust works really well in avoiding dual proceedings for persons that do own real estate in different states. It's also a great tool when I anticipate that if I have a will that's not leaving assets to direct heirs, and I anticipate that there may be some trouble when the person passes away by virtue of a will contest. And so instead of those heirs automatically having standing to speak to a judge, the creation of a revocable trust is a good tool because it would avoid the court proceeding and lessen the chance of anything getting contested and getting pulled into the court system. Then we have irrevocable trusts. So I use this a lot since, my primary focus is elder law. And so I use this for my clients that are more concerned about, they want to avoid the court proceeding. That is a goal, but they also have a secondary goal of preserving and protecting their assets in the event that something were to happen and they get sick, they start to age, and they need help either at home by virtue of an aide coming to the house to help them with their activities of daily living, or God forbid, they have a catastrophic illness where it requires a skilled level of care and they have to go into a nursing home. So this type of a trust would accomplish those two goals. It avoids probate, but it would also, after the look back period, which is currently 5 years in New York, it would protect all of the assets that we've moved into the trust dollar for long-term care planning as well. There are a third set of trusts, which are trusts to save on estate taxes. And so this is a problem I aspire to have in the future. And it's basically for, the wealthier residents of New York where there could be a potential trigger or a tax when they pass away. So there are two taxes, which are called estate taxes, that you want to avoid. One is the federal estate tax on a federal level, and that's for individuals with over $15 million. And if you're a New York State resident, you also need to be aware that there is a New York estate tax, and that's for anyone with an estate, which would be any real estate properties, any, cash in the bank accounts, brokerage accounts, stocks, bonds, life insurance, and retirement accounts. So if your net worth is over $7,350,000, then we can do more sophisticated type of planning to help you eliminate or reduce your estate tax. Okay. So I threw a lot of information at you, but basically there are different types of trusts, three different categories. One is the revocable living trust, primarily, just to avoid a court proceeding when you pass away. And that's you would be fully in control of everything. Second type of a trust is an irrevocable trust. We refer to it as a Medicaid asset protection trust because we use it mostly in conjunction with hopefully getting you to a point where you're qualified for Medicaid more easily because you are putting your assets in, and then hopefully, you make that 5-year look back period. And then the third category is for the wealthier, where we're more concerned with avoiding federal or New York estate taxes, and that also usually involves the creation of an irrevocable trust. Okay. Now we're going to discuss protecting your assets in the event that you need long-term care, which we touched on a little bit. So long-term care means care that you would need for the rest of your life. So through aging or, God forbid, a disability, it's either aid care in the home to help you with activities of daily living, such as walking, bathing, feeding, dressing, toileting, things of that nature. Or, God forbid, if you need a higher level of care that you cannot obtain in the house, even with help, then we're looking at nursing homes or skilled nursing facilities that provide hospital level of care. And there are 3 ways that long-term care is paid for. One is privately, which means you would pay out of your pocket. And just to give you an idea of what that is from a practical perspective, if you're hiring an aide to come into the home to help support you, what I'm seeing now as the average range is anywhere between $20 to $45 an hour, depending on if you're paying someone or if you're going through an agency where they're sending an aide that's already been vetted and insured. The second way is through long-term care insurance. If you've, thought ahead and kind of been proactive and planned ahead and obtained one of these policies when you were younger and healthier and able to afford the premiums, then you can submit a claim and the insurance, will send you a check to offset those costs. So if you can't afford that level of care, and I didn't mention nursing home care paying privately is close to $20,000 a month right now. So, it's unaffordable for most people. So if you can't afford to pay privately or you don't have long-term care insurance, then usually the only other remedy for you would be to apply for a program under Medicaid. And that would be through either community Medicaid, that is home care, where the aides come to the house and it's paid for through the program, or institutional Medicaid, which would pay for your nursing home care. Okay, so protecting your assets if you need long-term care. Your assets include your personal residence, any of your liquid assets. And again, if you're applying for Medicaid, it's services in your home, which is community or home care, or nursing home care. The best plan, if you're concerned with aging and protection of your assets, if you don't have a long-term care policy, is to create an irrevocable Medicaid asset protection trust and be proactive. So do it, while you're still healthy enough and it's foreseeable that you will make that look back period, and that at least for 5 years, it's foreseeable. No one has a crystal ball, but you just want to be proactive in your approach, that you're not waiting until a moment of crisis to try to put this into play, and just maybe planting a seed or thinking about it earlier and trying to arrange for that, so that in the event that you need it in the future, everything is already in that trust, insulated and protected against the costs of long-term care, which, like I said, can get very expensive pretty quickly. When and why should you update your plan? So basically, we always say 3 to 5 years or upon a major life event. If you're getting married, upon the birth of a child, a grandchild, if you're going through a divorce, if you're filing for bankruptcy or having some type of a creditor issue, if you have an impending lawsuit, when you're retiring is a really good time for you to really start and think about this and maybe create that trust. Or if you have the diagnosis of a major medical issue, that would really be, you'd hear a siren would go off for you to do something, and prompt you to meet with someone to try to create a plan, get these really important documents in place, or God forbid, upon the death of a loved one. So it's usually 3 to 5 years. And that doesn't necessarily mean that it has to be updated, but it's just like a check-in that you would have with your attorney, just to see, does the plan still work with the current laws and the changes with the laws? You know, the laws change constantly. And so you just want to make sure that you have a fluid plan. And or, before the 3 to 5 years, if there has been a major life event, which would prompt you to, again, call your attorney and just make sure that everything still works and it's what your current wishes reflect. So, what do you do now? You should reach out to your attorney if you haven't already, and just check in. And like I said, make sure that the plan still works. If you don't have a plan, I would urge you to contact, an experienced attorney that can help you with your planning, and just kind of make this part of your New Year's, checks and things that you should be doing, to make sure that you have everything in place and you have peace of mind, most importantly. So today, in a short time, we discussed very important, crucial estate planning documents, how to create a comprehensive estate plan, which would include decision-making documents in the event that you're incapacitated, how to leave your assets in a secure way, and protecting and preserving your assets in the event that you should need long-term care in the future. Okay, so we have a few minutes for questions. So far, I'm not seeing any. What you should also know while we're waiting for some questions is that Medicaid also changes and updates their numbers for qualification purposes and eligibility, usually the end of December and sometime in January. So they start releasing all of the updates so that we can update all of our resources and let all of our clients know what those updates are. And we still are waiting on quite a few. But just to give you an idea, the thresholds or the amount of assets that you can have if you're currently applying for Medicaid in this year, 2026, is $32,532. So you can't have any more than that. Otherwise, you won't qualify under either program for home care or for nursing home care. Someone did write in, is there a minimum asset amount you can keep? Oh, so that was the question that I just answered. So that resource amount, yes, for an individual is $32,532. Sometimes couples apply and we haven't received the updated resource amount for couples yet. Special needs concerns. Yeah, so if you have a beneficiary, a child, anyone that you want to leave any of your assets to, it's really important that you speak to your estate planning attorney, because there are ways for us to create a supplemental needs trust in order for that person to still be able to benefit from the money, the assets that you want to leave to them, but it won't compromise their eligibility for any of their government benefits. So it's really important for us to have that discussion and an analysis of what benefits are they receiving. And so we make sure that we're leaving specifically their share in a protected, secure way and not just disinheriting them, because we don't have to do that. You can still provide for them, but it does have to be through the virtue of a special type of a trust. Medicaid, I have another question. What is a Medicaid remainder trust? So the supplemental needs trust that I was just explaining for a disabled individual who is receiving assets. There are two types of trusts that fall under the umbrella of a supplemental needs trust. The first one is called a third party trust. So that's when it's the assets of another person, leaving it for the benefit of the disabled person. So for example, the parents of a disabled child, that would be a third party trust. And that money would not, at the end of the beneficiary's life, or if there's anything left in that trust remaining, does not go back to New York State as a payback. But if the money or the source of the funds was the individual's and not anybody else's, then the type of trust, like from a personal injury lawsuit or by virtue of them inheriting money, and that the person that left them the money did not do the proper planning, then it would be a first party supplemental needs trust. And when the beneficiary passes away, the rest of the unused trust funds would be basically clawed back by New York State. So that's a Medicaid remainder trust. Another question is, do you need a power of attorney if you are married? Great question. Yes, you do. Even if you're married and you have all of your assets jointly, you do need a power of attorney because any real estate, you do not have the authority to legally sign your spouse's name on any legal documents. So if one of the spouses gets sick, which is really a common occurrence, unfortunately, that I see a couple times a month at least, is that I can take all the assets from the sicker spouse and transfer them to the well spouse, and that qualifies for an exemption under the Medicaid rules. So I can, in a crunch, during a crisis, I can still potentially protect everything, but it's contingent upon that sick spouse having a durable power of attorney, appointing someone as an agent that can facilitate those transfers. So married couples absolutely need durable powers of attorney. Everyone needs a durable power of attorney. I even prepare them for my clients when their children are going off to college, as long as they're 18 or older, they can have their own set of advanced directives. So everyone who's an adult and competent should have a set of advanced directives for sure. You're very welcome. Okay, Cindy.
Thank you, Diana, for that very informative presentation. So why choose Russo Law Group? Our clients have consistently commended us for dedication, accessibility, and comprehensive service offerings that bring them peace of mind. We're a law firm founded in 1985, so we're going to turn 40 years old. We are 40 years old, I think. And we have 3 convenient locations on Long Island. We have a staff of 9 attorneys on hand to help at a moment's notice. So just give us a call.
And come and see me in Garden City.
Yes, Diana's our lead planning attorney in Garden City. So I invite you guys to visit our website, vjrrussolaw.com, to further explore our service offerings and all of our informational collateral, such as additional videos, blog posts, articles, and our calendar of events. I'm going to leave this up for a second. Please follow us on our social media pages. You can find tons of information on there as well. So we have YouTube, TikTok. Follow us. And thank you so much for attending. Please stay tuned for the survey that will come on the next screen at the end of the presentation. We value your feedback, so please fill it out. Thanks so much, Diana. Do you want to close us out?
Thank you so much, everyone.
Thank you. Bye.
Bye.